Namaskar. Good evening to all of you. On behalf of the Honorable Supreme Court of India, Honorable High Court of Delhi, and the Delhi International Arbitration Center, I extend a warm welcome to all the distinguished invitees to this inaugural function of the third edition of the Delhi Arbitration Weekend 2025. Your gracious presence here adds immense value to this hallowed occasion. On this occasion, we are deeply honored by the august presence of Honorable Mr. Justice Bhushan Ram Krishna Gavai, the Chief Justice of India. I extend a special welcome to the Honorable Chief Justice Mr. Stephen Gaigler, AC, High Court of Australia, who is a globally acclaimed expert on international arbitration. I also extend a warm welcome to Honorable Mr. Justice D.K. Upadhyay, Chief Justice of the High Court of Delhi. At this juncture, I would like to inform this august gathering that very recently we lost Mr. Yashraj Samant, a key member of the Working Committee for organizing the last two editions of the Delhi Arbitration Weekend. In his honor and to acknowledge his significant contributions, we ask the dignitaries both on and off the dais to kindly rise and observe a minute's silence. Thank you for your respect and observance. I would now like to request Honorable Mr. Justice D.K. Upadhyay, Chief Justice of the High Court of Delhi, to present a shawl and a prabhavali to the Honorable Chief Justice of India, Justice Bhushan Ram Krishna Gavai. I would now like to request Honorable Mr. Justice D.K. Upadhyay, Chief Justice of the High Court of Delhi, to present a shawl and a prabhavali to the Honorable Chief Justice Mr. Stephen Gaigler, AC, High Court of Australia. Sir, we hope it serves as a reminder of your time at the Delhi Arbitration Weekend 2025 and of the timeless elegance of Indian craftsmanship. I would now like to request Honorable Mr. Justice Subramaniam Prasad, Chairperson, Organizing Committee, Delhi Arbitration Weekend 2025, and Judge, High Court of Delhi, to present a shawl and a prabhavali to Honorable the Chief Justice of the High Court of Delhi, Justice D.K. Upadhyay. This spectacular event, held in this beautiful city ever since 2023, brings together esteemed practitioners, scholars, and aspiring minds in the field of arbitration, which is more than just an alternative dispute resolution method. It is a testament to our collective belief in swift, impartial, and expert-driven justice. It is the bridge that connects different legal traditions, transcending borders to foster a global legal community. So, as we embark on a journey of intellectual exchange, dialogue, and collaboration, may I request Honorable Mr. Justice D.K. Upadhyay, Chief Justice of the High Court of Delhi, to kindly deliver the welcome address.
Honorable the Chief Justice of India, Justice B.R. Gavai, Honorable the Chief Justice, High Court of Australia, Justice Stephen Gagler, Honorable Judges of the Supreme Court of India, present and past, my colleagues from Delhi High Court, Honorable Judges of other High Courts, other dignitaries on and off the dais, senior advocates, members of the bar, participants, and all other who are in attendance today. It gives me immense pleasure to welcome you all to the third edition of Delhi Arbitration Weekend. I wish you all a very good evening and namaskar. It is a matter of great pleasure for me to deliver this welcome address. I welcome Honorable Chief Justice of India, who has been an integral part of Delhi Arbitration Weekend ever since its inception in the year 2023. He has been a guide for all of us and has always been committed to ensure that this event continues to maintain its high standards. We have certainly bothered him on multiple occasions to seek his guidance, and he has been very kind to offer his time and attention to every minute detail of the conference. Let me share some personal experience of working with Honorable the Chief Justice of India. During my tenure as Chief Justice of Bombay High Court, I got multiple opportunities to accompany His Lordship to various judicial events across the length and breadth of state of Maharashtra. What I found in him is that he is full of energy and he takes keen interest in resolving the administrative issues concerning the high courts. As my guardian, he has always guided me and inspired me. About the energy that he possesses, anyone can be envious of him. After completing a tour to a district court, taking stock of infrastructural facilities there, inaugurating some court building, addressing the lawyers and judicial officers at large, His Lordship immediately used to return back to Delhi to attend the call of his duties, and during the travel time of 2 hours from Bombay to Delhi, he used to read the briefs which were to be taken up in the court the next day. His charm never diminishes. My gratitude is also due to Honorable Judges of the Supreme Court who have been source of guidance and inspiration, and many of them have been part of earlier versions of Delhi Arbitration Weekend. I also welcome Honorable Stephen Gagler, Chief Justice of High Court of Australia. His presence is not only a matter of great honor for all of us, but is also a testimony of the truly global character of Delhi Arbitration Weekend. Australia has evolved significantly in the field of international commercial arbitration. The Australian courts have adopted a consistent pro-arbitration stance in various cases concerning international arbitration. And it is fully befitting that Justice Gagler is present amongst us today to share his insights. I am confident that his valuable experience shall add immense value to the proposed discourse in this conference. Having said that, Justice Gagler, I also hope that you find time to visit around the beautiful city of Delhi and take some good memories home. We shall remain committed to ensure that you have a good time with us. My colleagues on the bench of Delhi High Court and judges from other high courts deserve special gratitude. I also acknowledge the presence of our international delegates who have traveled from different corners of the world to be with us and granted us an opportunity to host them and benefit from their vast experience. Their participation testifies to the fact that arbitration is truly a global language of justice, transcending national barriers. The distinguished speakers and delegates of DAW 2025 represent the finest in the world of arbitration, and their collective wisdom and knowledge will make this event an effective platform for the exchange of progressive ideas. In 2023, we began with a vision to bring together diverse voices in arbitration. Within a short span of 3 years, the Delhi International Arbitration Center has established itself as one of the leading fora for scholarly dialogue and institutional collaboration in the field of arbitration. The third edition of Delhi Arbitration Weekend is not only an academic or a professional gathering, but a collective reflection of India's aspirations to emerge as a global hub for international arbitration. The significance of this weekend lies in the breadth of its themes and the depth of its participation. The Delhi Arbitration Weekend has been conceptualized as a platform where contemporary issues in the field of arbitration are deliberated from a global standpoint. Every jurisdiction brings a new experience to the table. The nature of subject matters, the nature of litigation, the nature of litigants, the prevalent statutory framework, etc., are some of the influencing factors. Therefore, the infusion of local influence in the practice of arbitration cannot be ignored. However, we must strive for uniformity to the extent feasible by calibrating our practices from time to time. Unless we expose ourselves to better ideas and practices, we may not be able to unshackle ourselves from the local influences. We must be mindful that every now and then the practice of arbitration finds itself in an inherent conflict with the general civil procedure of the country. Every jurisdiction finds a different solution to this persistent problem, and the solutions are fine-tuned to the specific facts of the case. However, every such instance is a reminder that there is significant scope for academic engagement in the field of arbitration, and I must congratulate you all for participating in this discourse. It is only through deliberation that we can find lasting ideas to such inherent conflicts, and this third edition of Delhi Arbitration Weekend gives us this opportunity where we can initiate a debate on all the relevant topics and concerns to situate arbitration within the broader social, economic, and technological transformations. As we embark on 3 days of intensive deliberations, the discussions we hold here and the ideas we exchange, I am confident this will shape the course of arbitration in India and contribute to its evolution globally. Arbitration, as we all know, has become the cornerstone of modern commercial dispute resolution. In a world characterized by cross-border transactions, digital transformations, and geopolitical complexities, arbitration offers neutrality, efficiency, and expertise, the qualities that traditional litigation has often struggled to provide in complex commercial contexts. Yet, we must be candid in acknowledging that the arbitral processes do not come without its shortcomings. Issues such as procedural delays, questions of independence and impartiality, enforceability of awards, and the role of courts in balancing minimal interference with necessary oversight continue to occupy the center stage. With our growing integration into the global economy and India's aspiration to be an international hub for international arbitration, the choices we make today will define the effectiveness of our system in the coming years. For Delhi to be the preferred seat for a large number of arbitrations, the Delhi High Court has played a pivotal role in developing pro-arbitration jurisprudence. Our approach has been guided by two fundamental commitments. First, to uphold the ideals of party autonomy and institutional integrity, and second, to ensure that arbitration is not plagued by delay or inefficiency. The integration of artificial intelligence and other technologies enhances the efficiency of arbitration. While increasing the efficiency of the process, AI comes with its own striking challenges. While AI can enhance and support the conduct of arbitration in multiple ways, it obviously cannot completely replace human arbitrators because the human element in the resolution of disputes cannot be done away with. It is thus incumbent upon us to formulate the guidelines that will shape the future of assimilation of artificial intelligence in the functioning of arbitral tribunals, preserving the efficiency while ensuring that justice delivery is not impacted by over-reliance on AI. While a tribunal may take the assistance of artificial intelligence to perform non-judicial tasks that do not require application of judicial mind, the task of adjudicating a dispute cannot be delegated to artificial intelligence, as the human conscience lies at the heart of delivering justice. Another extremely important topic is India's stride towards being the seat of international commercial arbitrations. The reliability of an arbitral seat is measured not only in its legislative framework, but also in infrastructural and institutional framework and judicial support that sustains it. Seat gives legitimacy to arbitration. Parties choose a particular seat of arbitration because they are assured that awards will be recognized and enforced. Indian courts, and especially the Supreme Court, has demonstrated a clear intent to expeditiously decide the challenges and enforce the awards by adhering to limited contours of interference and judicial review in order to ensure that complete justice is served. Further, it is also imperative that the enforcement of interim measures and emergency relief must be effective and certain, so that the subject matter of dispute between the parties is preserved till the time the dispute is finally adjudicated upon by the arbitral tribunal. The theme of investment arbitration will see a profound discourse in this edition of DAW on the challenges it faces and the way forward. The legitimacy of investment arbitration lies not in its ability to protect capital alone, but in harmonizing private interest with sovereign responsibilities. There are multiple global challenges that may impact investment arbitration. One such striking challenge is environmental concerns. Environmental issues have become central to investment arbitration because many disputes involve activities such as resource extraction or projects with significant ecological impacts. Tribunals in such disputes thus must balance investor rights with the state's duty to protect the environment. This requires nuanced consideration of international law, treaty obligations, and scientific evidence. These challenges persist due to inherent tension between protecting investments and ensuring environmental sustainability. Ultimately, the future of investment arbitration will depend on achieving a careful balance between economic growth and environmental protection, thereby safeguarding investors' right, state sovereignty, and global sustainability. India's stride towards being the seat hinges heavily on another important consideration, that is, the conundrum between the principle of party autonomy in arbitration and the appointment of independent arbitrators. Party autonomy allows parties to structure appointments as they deem fit. However, the unqualified principle of party autonomy could lead to practices incompatible with the integrity of the arbitral process. Lastly, the issue of drafting enforceable awards has assumed great significance lately. An arbitral tribunal may hear the finest arguments and weigh the most complex evidence, but if its award is ultimately unenforceable in practice, the process becomes futile. The United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, 1958, commonly known as the New York Convention, has created a global framework for the enforcement of foreign awards with minimal interference. Yet, the strength of this framework depends not only on the national courts, but also on the manner in which arbitral tribunals draft their awards. An enforceable award must speak in a language that is clear and well-reasoned. I would also like to take this opportunity to extend my heartfelt appreciation to the organizing committee of Delhi High Court and the Delhi International Arbitration Center, who have worked tirelessly to curate this event. This commitment to excellence has ensured that this platform brings together the best of scholarship, practice, and policy. As I welcome you all today, I am confident that you would thoroughly enjoy and participate in the technical sessions over the next 2 days and would contribute to enrich the discourse. I also hope that you would enjoy your time with us and would experience a taste of Indian hospitality. Rooted in Sanskrit phrase Vasudhaiva Kutumbakam, which means the world is one family. I will recite the complete shlok where this phrase Vasudhaiva Kutumbakam occurs. Ayam nija paroveti gadana laghuchetasam udar charitanam tu Vasudhaiva Kutumbakam. Translated into English, it denotes that for those who have a small heart, their thinking is that this is their own and that is someone else's. For those who have a big heart, the whole earth is their family. On this note, I thank you all for joining us here today and convey my best wishes to all the participants. Thank you. Jai Hind.
The cornerstone of any great conference is an opening that sets the stage for deliberations and inspires the minds. Thank you, sir, for giving us that perfect opening. Arbitration, as we know, stands at the intersection of law, commerce, and international relations. To give us a global perspective on this evolving field, we now have the pleasure of hearing from our keynote speaker, the Honorable Chief Justice, Mr. Stephen Gageler, AC, High Court of Australia.
The Honourable Chief Justice of India, the Honourable Chief Justice of the Delhi High Court, Honourable Judges of the Supreme Court of India and the Delhi High Court, distinguished guests, ladies and gentlemen, it is truly an honour to be with you this evening at an extremely prestigious event in a very vibrant city. I thank the organising committee of the Delhi Arbitration Weekend for the invitation to speak. I thank them for their generous hospitality, and I thank them for organising what I am sure will be yet another very successful annual arbitration conference. My presentation tonight is entitled The UNCITRAL Model Law, a model of dialogue between the international and the domestic. The concept of dialogue is often discussed in constitutional scholarship. The idea is that in a constitutional democracy, the judiciary on the one hand and the legislature on the other engage in a dialogue which shapes and defines the boundaries of the law. In this presentation, I adapt the concept of dialogue to describe the relationship between the international sphere and the domestic sphere in shaping and defining the boundaries of arbitration under the UNCITRAL model law. I propose to talk about this dialogue in 4 stages. The first stage concerns the creation of UNCITRAL, that is the United Nations Commission on International Trade Law, and the international development by UNCITRAL of the model law as an extraordinarily successful example of what was termed by the great Dutch legal scholar Aaron Brosch as an exercise in international legislation. The second stage concerns the domestic implementation and interpretation of the model law in its original form. The third stage concerns the international updating of the model law based in part on the experience of those domestic jurisdictions which had implemented the model law in its original form. The fourth and current stage concerns the domestic integration and reinterpretation of the updated model law, having regard to its international origin and to the need to promote uniformity in its application. Stage 1, creation of the model law. The origins of the model law cannot be fully appreciated without looking at the foundations of the system that brought about its creation. In August 1941, in the midst of the most destructive war humanity had ever experienced, two world leaders sat together off the coast of Newfoundland. Franklin D. Roosevelt and Winston Churchill then and there committed to the ideals of the world they sought to forge after the war in a declaration later dubbed the Atlantic Charter. In January 1942, 26 nations, including India and Australia, committed to the principles of the Atlantic Charter in a joint declaration known as the Declaration by United Nations. As the name suggests, the Declaration by United Nations was the seedling of the post-war creation of the modern United Nations. Much has been made of the commitment to peace and to the seeking of abandonment of the use of force that defined the Atlantic Charter and underlay the formation of the United Nations. The first purpose of the United Nations, as set out in Article 1.1 of the UN Charter, is to maintain international peace and security. However, in the Atlantic Charter, placed below the commitment to territorial integrity, but above the commitment to a world without the use of force, was the commitment, and I quote, to bring about the fullest collaboration between all nations in the economic field with the object of securing for all improved labour standards, economic advancement and social security. The commitment came to be reflected in the purpose set out in Article 1.3 of the UN Charter to achieve international cooperation in solving international problems of an economic, social, cultural or humanitarian character, and in Article 13 of the UN Charter, which provides for the United Nations General Assembly to foster international cooperation in these areas. This is not to suggest that the story of international commercial arbitration starts in the post-war period. The practice of arbitration has ancient roots, including here in India. Many significant organisations that continue to shape international arbitration, like the London Court of International Arbitration and the International Chamber of Commerce, have their origins in the late 19th and early 20th centuries. But there was something unique about the post-war period. For centuries before, the world's economic circumstances had been slanted in favour of a small group of trading enterprises in a small group of countries in Western Europe. In the post-war period, as decolonisation occurred and new nations emerged, there was increased impetus for bodies concerned to facilitate international trade to be truly representative of the wider order. The establishment of the United Nations provided a forum for this wider representation. The forum quickly came to be utilised by those hoping to streamline international commercial arbitration. In 1953, the International Chamber of Commerce drafted its own wish list international arbitration convention, prompting the United Nations Economic and Social Council to set up a process which led to the holding in 1958 of a conference in New York, the city that gave its name to the resultant convention, being the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. 4 years later, in 1962, a colloquium convened in London by the International Association of Legal Science highlighted a lack of cooperation between bodies in the international arbitration field, leading some present to suggest that the United Nations should take up the issue. The issue was taken up and championed in the General Assembly of the United Nations by Hungary. The outcome was the establishment of UNCITRAL by resolution of the General Assembly in 1966, with the express mandate of promoting the progressive harmonisation and unification of the law of international trade. Justice Sabharwal of the Supreme Court of India highlighted the centrality of this mandate when he observed that the United Nations established UNCITRAL on account of the fact that the General Assembly recognised that disparities in national laws governing international trade created obstacles to the flow of trade. UNCITRAL's fulfilment of this mandate has been facilitated by its broad-ranging membership, consisting of 36 states, 9 African, 7 Asian, 5 Eastern European, 6 Latin American, and 9 Western European and other states. Its practice of reaching decisions only by consensus, too, has reflected a commitment to being a body